Good afternoon, everyone, and welcome to our session on GDPR, which will be recorded and available afterwards. We're really pleased to be partnering with Wessing here today to focus on a number of critical business issues, the most prominent being GDPR, where we intend to kind of challenge a lot of the myths and misconceptions that are going around at the moment regarding this new regulation and just provide you with some practical guidance on what you can be doing to be ready. So it's more of a focus really on operational and legal best practices and to really challenge a lot of the sort of scaremongering, confusion and mixed messaging which is actually being put forward to global businesses today. So just to introduce myself as way of background, my name is Simon Gleeson. I'm a partner at Blick Rothenberg, a market-leading accounting, tax and advisory practice. We provide critical business support and BPO services to global organisations, and our clients really range from start-up businesses to those larger multinational companies with subsidiaries around the world. So our role, we support them throughout their entire business life cycle and look to be a catalyst for their continued success. Today, GDPR impacts every kind of multinational, global, international business, and our approach is to focus more so on the positive outcomes it will bring, such as organisational change and a new way of working. So one real immediate example here today is the fact that we're seeing more and more of these initiatives, and they are driving collaboration, transparency between vendors, customers, and the legal and the professional services. So it's going to be around for a while. We think it's going to be a pivotal issue for many years to come. But as Elizabeth Denham said, the UK Information Commissioner, she said recently that it's important to see that GDPR will change data protection, but it's an evolution, not a revolution. And to some companies who are already compliant with the current data protection laws, it's seen as a step change. So our approach today is not to digest the 88 pages long full regulation or go through every and any of the 99 articles that exist out there, but just focus on the key areas that impact you and the practical ways forward so you can be prepared. And to help us, guide us through a lot of this noise is Chris Jeffrey, of the global law firm Taylor Wessing. Chris heads up the technology and privacy team here in London, and he and his colleagues today are really advising over 30 different projects and clients as we speak. So momentum is definitely building. On our agenda, we're going to cover why does GDPR matter, what are the consequences to you for non-compliance, the top 10 myths and misconceptions which are out there, how you can get ready, what it means to you as a business, what do you need to review and to change, particularly when it comes around existing vendors and partner contracts. The finer points, the more critical points, and potentially some of the more impactful ones like employee data and data breaches, and what's available to you in terms of tools and checklists that you can research after this call. So, Chris, we see a lot of confusion, fear and panic in the system, and on the one hand you see companies that are quite concerned around the penalties and the impact on them as a business, and then the other side there's others saying it's just a little bit of compliance work. You could even say it's apathy. So why don't we start off with what is GDPR and why do you think we have this kind of varied degree of engagement?
Yeah, thanks Simon, and hello everyone. I think you're right. I think there's an awful lot of noise and confusion around GDPR, and it's important before you dive into scaring people about all the work that needs to be done to take that step back. So in a nutshell, what we're looking at is a complete rewrite of European data protection law. Now, we've had data protection law since the mid-90s. We have the directive of 1995 implemented throughout the European Union, and this GDPR covers a lot of the same ground. It regulates the collection, use, sharing, transfer around the world of personal data. It has a number of individual rights, some new and some stronger than the existing directive, and it has much more rigorous Germanic levels of enforcement and compliance, you might say. So it's right to say that it's an evolution and not a revolution. The real key for me of what's new in it, though, is probably two elements I would pick out of those 88 articles. The first is the stress on data governance and not just on compliance. What the GDPR does that the existing directive does not is really drive a level of process and procedure and policy around personal data, both internally within an organization, but also with their vendors and customers, way in excess of what we have at the moment. And that's what I mean by the rigorous, detailed requirements, the Germanic levels of thoroughness. For anyone on the webinar who's done business in different European countries, they will know the UK and Ireland are quite light touch, pragmatic, business friendly. The minute you start doing business that impacts personal information in Germany, you get a taste for what privacy can be like when you have local regulators who really want you to do everything. What the GDPR does is essentially take the directive and push the whole of Europe up to those Germanic levels of governance. So where are we at the moment? Well, a lot of larger businesses, banks, heavily regulated, massive multinationals are way down their GDPR projects. The rest of the business world, some haven't even started, some are well into data audit. Others are just sitting there thinking, how do I even start with this thing? It looks so big, it's so confusing, I don't know what hits me. How do I even begin to look at what a GDPR project should look like?
So, to start with the obvious, and the biggest fear, myth number one, everyone's going to get fined.
And well, I mean, some people are going to get fined, but not everyone is going to get fined. The only good thing about this, if you're in an organization where you're pushing for attention or budget or focus or resource, fines at a maximum of 4% of global revenue can be a useful way of getting board attention. Beyond that, I think the fines are largely overplayed. If you look at the GDPR, it has a whole list of compliance steps. There's warnings and reprimands and orders, and I think fines will be reserved for the really egregious kinds of behavior. We've even had guidance now that says the regulators should look into whether a breach was intentional, whether people followed their data protection officer's guidance, a whole string of stuff which tells me that if you aim to be the good corporate citizen and you prioritize your GDPR steps in a way that makes sense for your business, how big you are in Europe, the kinds of data that you hold, you should be able to avoid the fines. But as I say, it can be useful if you're not getting enough, if you're not getting attention. But the key thing for me then is at the moment you really get your arms around the personal data coming into the business and you prioritize and plan which of the remediation steps are right for your business at your stage.
Okay, good starting point. We read a lot about them in the news, I think for different reasons right now, very political ones, shall we say. But still, when it comes to GDPR, I'm hearing comments like this is just about Google and Facebook.
Yeah, and because they're always, as you say, for privacy, for other reasons, they're often in the news. Google, it's public knowledge, has been fined, whether it was for Wi-Fi data being picked up. Facebook are often in deep discussions with the Irish regulator around rolling out new products. And because of the volume of data they hold and their high profile, they're often under the existing directive, in the crosshairs. But it isn't true, and I think it's a really important point, that it's not just about the businesses at that level. One key thing we're seeing, for people in the B2B space, if you're a platform, maybe a cloud-based platform selling services, and you process the personal data of your customer, GDPR is cropping up in their due diligence. So in their questionnaires, in their procurement playbook, and in the template contracts that they push, they all want to know that you as a processor, as we call it, will be GDPR compliant. So a key impact for service providers and technology providers not getting compliant, not getting your arms around this, can actually block you sealing business in Europe or make it very challenging to keep existing clients. The other point I'd make is we often think about consumer data as if that's the only thing that matters in EU privacy. But even if the only personal information you collect is about your own employees in Europe or your clients' employees in Europe, then you're still impacted by GDPR. Now, HR data, in terms of the steps you need to take, is actually in practice a little bit easier than consumer data. There's a real focus on the transparency and the amount of detail that you provide to your employees about what you do with data around them. So you shouldn't underestimate that, but it is a little bit of a lighter touch. And the other point I would make, if you think about companies in their life cycle, GDPR is starting to crop up on significant funding rounds and in M&A, where an acquirer or a big investor coming in wants to know that the company they're going to throw their money at is at least in a GDPR process. Not compliant yet, because we're talking about May of next year, but at least is taking that seriously, so they won't have a massive budgetary impact and have to sign a huge check and get them ready in a real hurry.
Okay. So, I mean, we've heard quite a lot of reference around HR data. I mean, we see this on LinkedIn, on social, day in, day out. I think one of the key areas of alarm for a lot of HR leaders is around that you must have consent to use personal data, but, is that really right? And to be fair, I would say even hard to achieve.
Yeah, I think that's absolutely right. And you hear this an awful lot, and I do understand why. It's a very complicated bit of legislation, and people tend to pick one element they've heard about, and then they apply it generally across all data. So you do hear this notion that if you hold any European personal data, you must have the consent of the individual to whom it relates, whether they're a consumer, whether they're the target of marketing activity, whether they're an employee. And it is, although there's a grain of truth in there, it's actually not true as a statement. So two key things to think about. One is you need to have a really good idea of the personal data coming into your business, as I said before. Some kind of data audit, data mapping process to really get that documented and nailed down. Once you have that, you then take a step back, and where you're acting as a data controller, so you own that data and you're responsible for it, you need to work out what is the lawful basis on which I hold that data. That is something in the existing directive, which in truth, the vast majority of businesses have completely ignored, unless they're doing business in Germany, because they haven't needed to. So consent is only one of the available lawful bases for processing data. So it may be necessary, but because, as you say, Simon, it's actually really hard to achieve. The level of detail you need to provide, because consent needs to be unambiguous and affirmative. Think of cookie notices, but on steroids, where you need a consumer consent in the online world. People, all businesses are trying to say, let's find another lawful basis and only use consent when we absolutely have to. So they're looking, for instance, to say, maybe I need this data because it's necessary to deliver under a contract. So you need an employee's bank details to pay them, for instance. That's necessary for the purposes of the employment contract. Another important one is legitimate interests. Again, if you look at that in the HR context, if you do some reference checks in a recruitment process, where you have cybersecurity or policy enforcement around your existing employees to make sure that their use of the internet and email is compliant with firm policies and so on. That kind of stuff will come under legitimate interests. And also in the HR context, the regulators have always been clear that consent hardly ever works, because an employee is deemed not to be able to give a freely given consent as the GDPR requires, because that's simply not the nature of the relationship. So while some businesses will have to swallow that they need a consent, things like direct marketing, the use of cookies and so on will always need a consent, and you may need it to other things if you're in the online sector and you do online advertising, behavioral targeting, that kind of thing. You're going to need consent to a number of elements, but where you can, you try and put it in one of the other buckets.
Okay. And we did kind of cross over to myth 4, which is consent must be explicit, but do you think it's just the type of data that you collect for an individual, it can really vary by country? I mean, I noticed some of the guides and checklists you pushed out, you have an infographic that really just focuses on the different points in each and every country. So, I mean, there are certain things on here that I read around sex life, criminal records. I mean, that varied degree of information or access to that information in certain countries. So that's where you're sort of coming from the explicit side of things.
Yeah, no, that's absolutely right. So there's, in an earlier draft of the GDPR, every consent needed to be explicit, and people were stressing about what it meant. That is only the case for special categories of data, so health, sex life, criminal records, biometric, and so on. Explicit isn't defined, but I think what it means is it's really in the user's face, and it is absolutely crystal clear about what's going to happen with their data. For other consents, if you're not collecting that kind of data, it needs to be unambiguous and affirmative. It's going to be a lot more intrusive in an online flow than we're used to, but it doesn't need to be explicit.
Okay. When we talk to US companies in particular, I think I referenced it at the very beginning around, I wouldn't say apathy, but maybe a little bit naivety, that it's just around PII. And we heard that, some of us who aren't as accustomed to this legislation have to Google it to look it up. And then when you Google what PII is, you see lots of different descriptions about it. I mean, it actually sounds quite similar, but when you talk to European lawyers, there's actually seen as quite different, and I think that's where a lot of the naivety comes in, particularly for people that don't work within a kind of legal professional data security. So this is only about PII. I found that quite interesting, and what's your thoughts?
Well, this is one of the big bugbears for European lawyers. PII is a very US term, as you say, and essentially what PII says is information, it stands for personally identifiable information. Information is personally identifiable in US terms if it either contains or you can link it to an individual's name, email address, residential address, social security number. Now, because PII and personal data, they all talk about identifiability. There's a tendency in the marketplace, particularly in tech, because it's so US dominated, to conflate the two and to think that EU privacy is just about PII, and it ain't. EU privacy is around personal data, and that is a much, much wider category. I'll give you one concrete example. A case last year went all the way to the Court of Justice of the European Union, as we now call it, and held that an IP address, which is just a string of numbers which identifies a browser on the internet, in the hands of a website operator is personal data. Now, there's no way the website operator can find out the name of the individual behind that browser from the IP address unless they go to that individual's ISP and get a court order. But the court didn't care. They said it's still possible, and therefore that's identifiability. So something like an IP address or any anonymous identifier that's unique to an individual brings you within the realms of personal data, not PII, but personal data, and therefore within the realms of the GDPR. I'll give you another example very quickly from the HR context, where you have systems that monitor the activities of employees, on the IT systems, cybersecurity, that kind of thing. Often you won't see the name of the employee. Often the system will log a unique number that relates to that employee. Now, even if the system is designed so none of the support people looking in cannot see that it's John Smith, that unique ID under GDPR is personal data. Okay. Now, it's not the end of the world, but we do have to understand that. When we're trying to work out, what level of remediation is right for this business, given what they do, we do need to understand all of that personal data that's involved in the organisation.
Okay. We deal with companies headquartered in different parts of the world. Obviously, with Brexit as well, GDPR seems to have worked its way in around which countries are going to be compliant, where should you really truly host your data, depending on the types of services that you're selling. Countries in Latin and Asia, in some cases are not even tracking it at all. So I think one of the challenges that people talk about is that they're only really accountable to the country where they are headquartered in. I mean, that's actually quite common to hear that. So, you only answer to one national regulator. Is that truly the case?
Well, I think there's two scenarios I see, and I think the answer to your question is no, it's not the case, almost invariably. If we take an example of a non-European business with, say, European users or European employees, say they're headquartered in the US or in Brazil or in China, they may feel that really they only need to worry about their local regulators and their European presence is so small. But the GDPR is very clear that if you are monitoring the activities of EU citizens or trying to sell them stuff, even if you have no boots on the ground in Europe, you are still subject to the GDPR. Difficult though it would be to enforce it for the regulators in practice, you're in theory still relevant. Where you do have boots in Europe, when the GDPR was being discussed, this carrot was held in front of business, which said, okay, we are going to raise these requirements to the Germanic level, as I refer to. And I know that's going to be a lot of work, but don't worry. The good thing is you will only answer to one European regulator, and that's the one where you have your main establishment within the European Union. Now, what happened in practice is that because a lot of multinationals will base themselves in the UK, Ireland, Netherlands, or Switzerland, the likes of France and Germany started to worry that they would be unable to enforce the rules when it comes to their own citizens. So they chipped away at this principle. So what we call the one-stop shop essentially doesn't really exist anymore. So there's a whole raft of things where local countries can pass their own rules in addition to the GDPR, and it's particularly in the HR context. So if people on the webinar are based in France or Germany or have a presence there, you'll be very used to the fact that there can be works councils you need to consult with or get the approval of. All of that stuff, all of that local change around HR data is going to remain. It'll still be up to the national governments to make those decisions and up to those local regulators to enforce them. And that's been a disappointment for business, but that's what we're faced with.
Okay. So just on the topic of business, particularly within the sort of HR community again, anyone can make you delete all their data, which I thought that would be quite interesting, if not potentially something an employee, a disenchanted employee could be leveraging in a tribunal, for example, or HR-related matters for non-performance. I mean, these are all kind of day-to-day grievances and disciplinary matters, but if you're bringing somebody through a process and they're asking you to delete the data on which the process or procedure is based, I mean, it can be seen as quite contradicting.
Yeah. No, I agree. And this is, we've seen under the existing directive, if you have an employee going through a process, they'll exercise their right of access. They will say, I want to see everything that's been discussed about me. So if management have got round the table and had a discussion, Bob's not really performing, do we need to let him go? They try and get access to that. And actually, it's a little bit grey under current law about the extent to which they can or they can't. But of course, an employer will fight tooth and nail not to have to disclose that. This one is an interesting one because the right of erasure is made crystal clear. But again, there's a lot of myth-making around this. It's quite a technical area, but the bottom line is it is not the case that anyone can simply ring up or email in and say, you've got my data, wipe it. It's actually much more complicated than that. And there are often, I think the bottom line is, where a business has a good reason and a need to retain that data, actually there's usually a justification for holding on to it. But you do need to build a process by which those requests are considered. You've got a 30-day period under the GDPR to look at an erasure request or an access request and go back to the individual or the data subjects, as they're called in the GDPR world, and explain what progress has been made. So you need a process to deal with this.
But So I'm just thinking out loud. So if you take your employee handbook and you outline all your HR process around policies and procedures, grievances and disciplinary, I think is it fair to say now that companies need to review those and update them and put certain deadlines in around how long data can be retained if an employee was actually involved in such a scenario? Very HR.
Yeah, it's a great question, but I think the answer to that is yes. You definitely need to update your processes around that. I think the good news is where you need to retain data on the employee, and the wording is for the establishment, exercise, or defence of legal claims, and we're interpreting that to mean legal claims that have not yet been started. So where you need to keep, disciplinary records, performance records, because this employee may make a claim at some point, and you need access to that to show that, say, you went through a fair dismissal process, for instance, then you are entitled under the GDPR, or at least until we get guidance to the contrary, you can hang on to that. You can say, I'm sorry, there's some data here which we have a legitimate need to retain, recognised by the GDPR. That's the first point. The second point, I think, is that the other thing the GDPR drives is even if the individual concerned never gets in contact and says, wipe my data, there comes a point at which you no longer have a good enough reason. So remember, you collected data originally under a lawful basis. There comes a point at which actually it's now so out of date, there's no risk. For instance, you're beyond the limitation period for an employment claim.
Okay.
You need to ask yourself then, can I keep this data at all? And so our clients going through the GDPR process are all of them, without fail, having what we call a deletion schedule. So for different categories of data, there comes a point, and it can be 7 years down the line, for instance, that's when the Inland Revenue, talking to a bunch of accountants, that's when they can no longer come after you for most tax-related claims. So that would be an obvious one, okay, where it's a tax record, have I got a good reason to keep it beyond that period?
I don't want to stay stuck on this slide,
Yeah.
but I am just curious, are you seeing even M&A now in transactions where the acquiring company is trying to put provisions in place for the transaction to kind of keep data open on the management team, on the business, or is that just not GDPR related?
Well, they are. I think what I'm seeing is more sellers are worrying about that due diligence process.
Okay.
And they're starting to think, come GDPR time in May of next year, at what point in the due diligence process am I allowed to name my employees to someone looking in? There's an auction process and 15 companies are looking at it, then I think we'd say even now, those names should be blanked out. But that question is being asked. And actually, as with quite a lot with the GDPR, without all of the guidance coming out yet, we don't have all the answers. They will appear as time goes on.
Okay. So just moving swiftly onwards, it does seem a little bit of a contentious statement, and some might argue naive, but you need to change your privacy policy and tweak your contracts, and you're done.
Yes, and we hear this a lot. And the reason you hear that a lot is that every time a company's got to grips with the current regime under the existing directive, those have been really key elements. What they've done is essentially played around with the external facing elements of compliance. A privacy policy, a customer contract, maybe some FAQs. It's been compliance around the edges, actually, not for all organisations, but for a large number of them. And I think that those days are gone. And even if you're relatively small in Europe and you don't collect controversial data, I think there's a lot more that you need to do around GDPR than just make those tweaks to the external elements. And the key thing is, and we mentioned it on the slide, I talked about that governance piece, the things that you at least need to be thinking about. You may not need to do all of these. It does depend on what data you collect and what you do with it. But you need to think about governance elements like, do I need a data protection officer? Should I be doing a privacy impact assessment? Which is where you look at high-risk processing, and we have got some guidance about what that means, and you say, do I really need to keep all this data? Can I anonymize it? Can I pseudonymize it? And then you go through the whole process of analyzing your GDPR compliance and, of course, we hope, coming to the conclusion that it's all fine. So regulators where you have high-risk processing and even some intrusive monitoring of employees can qualify as high risk, will expect to see that analysis in that document. So I won't go through all of these, but I think the key point is some of this is going to be relevant to practically every business. An element of governance and internal compliance and process. Without it, you're going to look like you haven't really tried, and those are the businesses that I worry about come May of next year if they get in front of the regulator.
Yeah, I really like the point you raised that it's about showing your workings, but it's just showing an intention to address, to be ready, good corporate citizenship. And that's exactly probably the piece that's quite important now. A personal favourite of mine, Brexit means UK businesses don't need to bother at all.
Yeah, well, I guess people, I won't display my own opinions, but people who voted for Brexit probably think it's exactly to avoid this kind of regulation that we left. The bad news for them is that we're going to get GDPR or a UK equivalent version of it, whether we like it or not. That is certainly the policy of the government. That's what the ICO, the UK Data Protection Regulator, has said. And if you think about the timing, the earliest we'll leave the EU is March 2019. The GDPR comes into force on the 25th of May 2018. So we have almost a year where we're subject to the GDPR, whether we like it or not. And our regulator has said that it will enforce. Now, they tend to be quite a business-friendly and pragmatic regulator, but actually they are quite hot on certain issues. So I think it's still meaningful for UK businesses. They need to be ready for the GDPR. The data protection bill that we mention here is an appallingly badly drafted piece of legislation, to be fair. But what it tries to do is to mirror the core requirements of the GDPR, so they will be in place in UK law after we Brexit in March 2019, or later if there's a deal. And the reason for that is, if you compare us with the US a minute, at the moment within the European Union, all the talk of Privacy Shield and the Snowden revelations, the transfer of data all around the world, because the UK is part of the European Union, we're presumed to be adequate. So German personal data, French, Spanish, etc., can be hosted in the UK, can be processed and crunched and looked at in the UK without restrictions. If we leave the European Union in a hard Brexit as looks likely, we will then be in a similar position to the US is now. And unless we can show that we provide in our own law adequate protection for personal data, then we will need to have either an equivalent of the Privacy Shield or to have the model clauses in place. In other words, some actually quite painful compliance mechanism, even to have European data come over to the UK. Now, we think of ourselves as the digital capital of Europe, although Paris and Berlin might have something to say about that, but still, it's a huge deal if there's a risk that there's a legal problem for businesses in continental Europe allowing personal data to come to the UK. So for that reason, we'll have something like the Data Protection Bill, very similar to the GDPR, so we can turn around to the European Commission and say, you need to put us on the white list for data transfers, just like Canada are, and Israel, Argentina.
Because we're mirroring the same standards.
Because we have the same rules as you do. So although Brexit might point towards, lighter touch, more pragmatic, actually the reality of a connected world is that that's going to be very hard to achieve without threatening the digital economy of the UK.
It's a very poignant observation, because in some cases GDPR is being used as some countries feel like it's a competitive edge. Why go to the UK when you could go to Ireland, you could go to France, you could seek an alternative, and it's interesting to hear those observations because it's quite a topical point at the moment. I'm not in the legal profession, but even I know GDPR is really, it's not about security, and you've expressed and touched on so many different points around this. And the one thing that interests me is when you look at roles within a corporate team, we talk about CTOs, CISOs, we talk about HR, finance. I mean, do you put any particular weighting on who's responsible and accountable for making a company compliant, or is it like a shared responsibility across the ExCom?
Well, I think someone on the board needs to have responsibility for the GDPR. I think ultimate responsibility needs to lie somewhere. I'm not, even though I'm a lawyer and lawyers think obviously they're the perfect being, but it doesn't necessarily need to be in the legal team or the legal lead. But what I would say is it needs to be someone who is comfortable making those regulatory and compliance calls. Because the reality of GDPR is no business, literally no business, will be 100%. Everyone is making judgment calls. And so you may find, for instance, if it's someone in the engineering team or the security team, they're used to compliance, saying, here's a bunch of rules and I need to follow them off and tick them off. They're not used to making those risk assessment calls. When they say, okay, it looks like technically we're subject to that rule, say it's erasure or access, but actually when you look at the data we collect, who on earth is ever going to ask us to delete or access it? I know that sounds very robust when we're talking about those fines, but that's the reality of the conversations that you end up having. Certainly by May 2018, you can't comply with this whole thing. You have to pick your priority remediation steps. So it needs to be someone who's used to making those kind of calls, I think, that leads on the project, if that makes sense.
That's good. Very good. I mean, it's been a really interesting exercise. Just for the audience, I know we've recorded it as well, and I imagine that we will get through some of the kind of key practical points here already as well. So I'm just going to hand over to you. And I just suggest maybe picking out some of the major points.
Yeah. So
verbatim.
Yeah, I agree. There's more detail on the other slides for your reference. They're available too. But I was just going to go through these because we want to leave enough time for questions. Some of the really key practical points in terms of, well, what next? And so every business touching EU personal data has some work to do. I think the main thing I would say, don't fall into the trap and thinking, I'm not on the radar, I'm just too small. You'll either find, if you're selling B2B, that some European clients won't touch you because you're not in shape when they start to do your due diligence, or you'll find the reputational risk in B2C, for instance, will just start to cause real business concern. So everyone needs to do something, I think is a fair statement. Equally obvious, get going. May is only 6 months away. It's already tight for a business starting now to get the priority remediations done. Third point, it is a project. It's not a clipboard compliance process like a Modern Slavery Act statement that goes onto the website. You really need to get buy-in, particularly, I think, around the data audit and data mapping thing that we talked about at the beginning, where you get your arms around all the personal data coming in. And people bang on about data audit and data mapping as if it's some very complex process. It's not. It's basically having a sensible questionnaire and going around and asking your colleagues what personal information is involved in the business. Now, I talk to a lot of legal teams and a lot of engineering teams who think they know already, but I can tell you every single client we've taken through that process has found out things that they don't. And sometimes it's a straightforward security risk that there's customer databases on unencrypted laptops that the marketing guys take. I mean, it happens. It happens. It really does. And that shouldn't happen anymore because we know companies get fined for having personal data on unencrypted laptops. We've seen it a number of times. So it actually can be helpful from a pure cybersecurity perspective in that way. Anyway, there are always surprises. And if you don't find out, then Donald Rumsfeld's unknowns come into play and you're not making the right kind of risk assessment. So use a balance of internal and external resources. I mean, there are some friendly law firms, of which we are one of them. There are many consultants that you can use as well. I would look at all your options and make the right choice for you. Beware people selling on fear, as you said earlier, Simon. There are a number of companies out there who have a kind of a one-size-fits-nobody approach to GDPR. This is the way we do it. This is our fee. And just beware of a simplistic approach to what kind of remediation is right for you. Okay, I think we talked about governance and accountability. I was just going to touch for my last few points on vendor and partner contracts. One of the key remediation steps for all controllers. And let's just go back to the HR example as well, because that impacts every business. What GDPR requires is whenever you allow another party to access personal data you control, so it could be on your own employees. Let's say you use an outsourced HR platform, a Workday, a Swift, or whoever it might be, or you use someone to help you advise your employees on financial services, use someone else on healthcare and benefits and so on. The GDPR says you must slow down some very specific contracts onto them. Article 28 has a long shopping list of the kinds of stuff that a controller must put in a commercial agreement with a processor, and which a processor must put in a contract with a sub-processor. So it's really important to have those ready. For a lot of our platform and service provider clients, not having that kind of template now, which allows your customer, when they're going through their legal process, to say, yep, 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 and tick all those boxes, is really extending sales lead time. So that's a key point to bear in mind. So essential next steps, let's wrap up really quickly. Make the key stakeholders aware internally if they're not already. Consider budgets. Map data and create that inventory. Identify who is the lead supervisory authority. But even though that one-stop shop doesn't exist, if you're likely to be on the radar, it's worth engaging with the local regulator. Once you've got your ducks pretty much in a row, it's worth trying to build a positive relationship rather than have the first time you come onto their radar is when you think there's been a problem. If you're in the B2C space, privacy notices and consents are absolutely essential and actually a very challenging thing to balance with the desire to have an uncluttered user experience. In B2B, review all your contracts, your templates. Be ready for EU customers and partners asking some really tedious questions and imposing indemnities and unlimited liabilities, and have the team ready to deal with that. And then, just so we have time for some questions at the end, think about data subject rights. If you're not going to build tools and processes around them, at least have thought through why they're not relevant to your business and the data you hold. Look at policies around data breach response, data handling and report procedures. One thing we haven't touched on is that there's mandatory breach notification where there's a risk to individuals within 3 days to the regulator. So quite challenging and one of the shortest periods you'll find. Create that governance framework internally. Employee communications, that transparency piece with your own employees is absolutely key. And then think about whether you need a DPO. And with that, that's a long enough list to be starting with.
Okay. So I know that we've actually got 4 pages of questions here. We're going to do our best to answer maybe some of the key ones now. For those that we don't address, we will come back to you directly with a response. So, do you want to start with the first one?
Yeah. So, first question, is direct marketing for existing customers a legitimate business purpose? Now, the answer to that is yes, but. So, under the GDPR, there's a recital that says a possible example of processing under legitimate interests is direct marketing. So for a company marketing its own products and services to its customers, whether it's B2C or B2B, the GDPR seems to give you a bit of a pass. The complexity here, though, is that the GDPR is not the only show in town. The Europeans have decided to update what we call the e-privacy directive, and so the European Parliament, the Commission, and the Council are currently knocking their heads together to try and agree the e-privacy regulation. Now that does a similar thing to our rules on direct marketing. So if you want to direct market by email or SMS, then if it's B2C, the current draft of the e-privacy regulation, and it could change, although I doubt it, the current draft requires you to get a consent for email and SMS marketing. And the sting in the tail there is although it can be still an opt-out consent, it needs the levels of transparency and explanation and granularity that the GDPR requires. So in a way, it's good news. It feels pretty much like the current, it's opt-out, which is good. It doesn't have to be opt-in, although some companies prefer opt-in. The bad news is we're going to have to work on those direct marketing consents and say, right, is that clear enough? Is it unambiguous enough? Is it crystal clear that someone can say no and still access our white paper or register for an account or order a service and so on? I think we can safely say no direct marketing consent that you're using now will be good enough post-GDPR if the e-privacy regulation goes through in its current form. Some changes and improvements in that level of transparency will be required.
But I've heard a lot of fear around this, particularly from vendors who provide services and systems that support that type of activity. But when I think about it, in the past, there was always that thing around cookies consent, that there was some concern that you'd have banners going across every website and you had to say yes or no. But now, it just feels like it's so prevalent, it's just another kind of tick in the box. You don't even think about it now because it's a necessity.
I think that's right. The caveat to that, to people who do a lot online, we're still going to see cookie consents. That's also part of the e-privacy regulation. But what it's at the moment, a cookie consent is very much implied. No one's interested. We click on it, and then you just drop cookies. It's normal. There's hardly anyone who actually says, "Oh no, I don't want cookies." And if they do say that, most websites that have any reaction at all will say, "Well, I'm sorry, can't." Not all, but most will say, "I'm sorry, you can't access." E-privacy says if it's not an essential cookie, so if it's tracking or analytics, a whole bunch of cookies that a lot of websites drop, you still have to allow them access to the contents of the website or the app, even if they've said no to the dropping of the cookie. So there's an engineering change there. Now, it'll be very interesting to see how many websites, assuming the e-privacy ends up in that position, how many websites actually make the engineering change so there's a kind of cookie-free version of their website content. I think e-privacy is a really interesting one. It hasn't had any of the airtime that GDPR has. But for people in direct marketing, for people whose business is online and consumer-facing, it actually presents more challenges, I think, than the GDPR does.
Okay.
And a name I recognise, that used to be here. To what extent does the right of erasure capture backed up copies on servers? Yes, great question. So I think technically it absolutely does. I think it captures everything that's in digital form. But I think the reality here, and lots of clients are asking, you say there's a right to erasure, what does erasure mean? Because in the current digital environment, there aren't that many systems that wipe it in a way that the FBI or GCHQ would consider a hard drive to have been wiped. There's almost always a digital trail or backup servers or tapes or something. I think we don't yet know exactly where GDPR would land around that. I think, as always, it's the art of the possible. And my own view would probably be to follow, if you're in the UK, to follow the ICO's existing guidance, where they open the door to something equivalent to erasure, which is really around the data being put beyond use. And essentially what that means is it's still there, but it's heavily encrypted. There's only a limited number of people who can access it. And, in line with our stress on governance and accountability under GDPR, there's actually a set of rules for the circumstances under which that data can be reactivated and brought back into live use. So I think putting beyond use in that sense, for now, and for UK businesses, should be regarded as good enough. There may be some, in the massive multinationals or the banks who actually are building systems that will erase completely. But I think for the vast majority of businesses, that to me feels over the top. But again, that guidance change.
Okay.
It could turn out we need to move towards that.
Okay. So Just being conscious of time, I know we've covered quite a lot of ground today, and I hope those who are still listening have found it quite useful. We want to bring clarity, reassurance, and help you be prepared for change. In front of you, you should see a great source of information, an asset, I might say, to GDPR, which is the Global Data Hub, which is provided by Taylor Wessing, where if you go in there, you'll actually look at topics, updates, checklists, as well as aids that might assist you depending on your role within the business. I think, Chris, anything you want to add to that? Anything I missed within the hub?
No, I think that's a great summary.
Okay, good.
Thanks for that plug.
Well, I know you put a lot of effort into today. Really appreciate it. And if we can be of any further assistance, then please don't hesitate to contact us. And any outstanding questions, we'll look to come back to you and respond to you directly. But I would say thank you, and this now concludes today's session.